Good morning, everyone. Thank you for joining us. This is a mediation seminar webinar on mediation and negotiation in the virtual world, the ethics, the technology, and the best practices. Today, our guests are the Honorable John P. DiBlasi, who's had an illustrious 10 years on the Supreme Court of New York in the Commercial Division, where he has handled hundreds of matters. He is a well-known and well-sought-after mediator. And by the way, his resume is too long to read. I told him it should be longer because it's too short. But most of you who are involved in mediation, especially in the New York area, know Judge DiBlasi, whose reputation precedes him in most mediations. And we're also happy to have McKenna, who is the managing partner of the Fox Rothschild Philadelphia office. Lauren has been an attorney in that office actually since she was a young lawyer, has been her only actually job after law school was at Fox Rothschild, long illustrious career. Lauren is an expert in flood litigation cases and commercial litigation and just a really great trial lawyer. Thank you both for joining us. I appreciate you coming on. And my name is Rudy Rivera. I'm with Fidelity National Financial. I'll be moderating today's webinar. Let me throw this out to you. It's a new world right now. We went from everything in person to now everything in video. How has this changed the climate for mediation and negotiation? Judge, why don't we start with you? What's different now that's different that wasn't there before? Other than the pandemic, now we've got technology, but how has that affected your dynamic as a mediator?
That's a really interesting question from the perspective of a mediator who, and I know, Rudy, we had talked about this, had conducted proceedings virtually prior to the pandemic, but then making this dramatic shift over to a completely virtual process once the pandemic started. And fortunately at NAM, since we had the technology in place, we literally transitioned from a Friday to a Monday. What I found initially is that there was an incredible reticence on the part of the members of the bar to do mediations virtually. And that is for a multiplicity of reasons that I think we're going to discuss during the course of this webinar. But over time, once the realization came about that it was going to be impossible to come back in person, and I would honestly say in the, let's say, 3 years that the pandemic has been going on, I've only had 10 or 12 cases where the requests have come in to go back in person. What has happened in terms of the dynamic, and I'm hearing this from almost, I would say 90% of the lawyers that I speak to, is that now from beginning in a position where they were completely reticent about doing a virtual mediation, now the large majority do not want to go back to in-person mediations. And it's a unique scenario, and I know the panel has discussed this in preparing for the webinar because there are positives and negatives to it. I don't want to go too far into that because I know Lauren is going to touch on a lot of this, but I think, most importantly, from my perspective, is that we do have buy-in. And I think one of the most significant aspects is, for me, is that we have a participation of a greater number of stakeholders than we ever had before. But there are pros and cons to it. And I want to just flip it over to Lauren because I know she is going to talk about a lot of these specific issues. Lauren?
Thanks, Judge. Good morning, everyone. Pleasure to be with you all. In response to Rudy's question, I think it's been an evolution. At the start of the pandemic, we really didn't have a choice. If we wanted to move a case forward, we had to do it virtually. Most of us were not working in person. Certainly clients that I was working with were not in person, were not able to fly to a location to do a mediation as we might have done before the pandemic. So the first few months, I think, were really about just adjusting and adapting quickly to what we needed to do to keep cases moving. And as an attorney who gets retained as outside counsel by clients, part of my job at that point was sort of to build some confidence about doing a mediation virtually so that we could move cases forward. And we were pretty successful at that. I think now that the issue as part of the evolution is we have a choice, right? We've gotten a taste of what we had to do, and we've figured out that that works a great deal of the time. Sometimes we decided not to do things virtually. So I think there's now a level of strategy that goes into deciding whether you want to do a mediation virtually or not, because we have some choice about how we participate in the process. And to me, that's an interesting thing because it involves a layer of discussion with clients that we've never had to have before. You know, is this case going to be well served by us being at a mediation virtually with everybody participating in that manner? So to me, I think now we just have more to talk about, more to think about, more to strategize about as we approach mediation now that we're back in offices and traveling.
Well, where I see the dynamic has changed in that cases that are not of high value or high dollar amount are now much easier to mediate. And you can get the client involved more in the mediation because he's not traveling, you're not traveling. It brings the cost down. So cases where you have exposure, say, of 100,000, and that's what you're negotiating, it becomes much more easier to negotiate in those types of settings, and nobody has to travel. The downside is nobody has to travel. And so people want to get out, they want to go home. And oftentimes the mediation finishes at the 11th hour when everyone's ready to catch a plane.
I think that's a really important point, Rudy. You know, in preparing for today, we talked about our different perspectives. You as in-house counsel, me as outside counsel, judge as a former judge and mediator. But we all hit on the same points of the pros and the cons with respect to this process. And certainly there's an efficiency now that we didn't have before. We don't have to travel. We don't have that expense. That's not just travel expense, that's attorney time traveling for a particular client. I have the opportunity now to involve additional stakeholders at clients. I'm finding that sometimes clients are saying, the GC would like to join us for this. You know, I may be your report, but this GC would like to participate in the mediation. And so there's some opportunity to handle cases differently. And I think in some respects, it goes more smoothly because we're all sort of locked in virtually into one room, if you will, having conversations about, you know, the process and about settlement. So definitely there are some pros, but as we discussed in preparing for today, there's certainly some cons too.
You know, I think the big takeaways from my perspective as a mediator is that, and I've actually found that while I was always incredibly busy, I am busier now than I have ever been, primarily because of the ease of scheduling, the fact that there's been an incredible decrease in the number of cancellation. I think to Lauren's point, the fact that we have the participation of stakeholders who otherwise would not have traveled to the mediation site. And I've actually had stakeholders, and I think Lauren made a good point, whether it's a general counsel from a corporation or officer of a corporation, say to me, in all of the years that I've been doing this, I've never attended a mediation. This is the first one that I've actually been to, and it's incredibly helpful to me because I really better understand the process. Well, it's incredibly helpful to me as the mediator in this respect that I get to speak directly to the stakeholder, where very often it's almost like a Wizard of Oz game where the stakeholder is hiding by the attorney. And every time I have a communication with the attorney, there has to be a relay to the stakeholder in Indianapolis or Los Angeles or California, as opposed to me doing what I think is probably one of my most important functions, which is most importantly, listening to the stakeholder, which is critical. The panels discuss this, you know, just because it's a corporate mediation or arbitration, whatever it happens to be, emotions play a significant part, but also the ability to give the person who's going to make the decision with respect to settlement my direct input without having the attorney in between as a filter. The last thing I would just tell you physically, which is a logistical thing, and not because I'm going to turn 67, There are a lot of logistics involved when you're in person. And there are benefits to being in person, because I know, as Lauren and Rudy and I have talked about, you get to see the other person in person. We'll talk about that, what you can observe about the other person, the attorneys. But logistically, from my standpoint, I am not moving around as much. Setting people up in rooms and breaking them out is far easier. So that's a benefit, although we also have the other side of we're not seeing them again. But from the mediator's standpoint, I can move much more efficiently and quickly virtually than I can when I'm in person. Although on the other side of it, there are numerous benefits to being in person.
But what I miss and what I think is lacking is the ability to go outside the hall, talk to your, opposing counsel separately, perhaps, where the clients or the stakeholders are in the room. You don't have that ease to move around like you used to. And I've had experience using Zoom rooms, but everyone's in the room. And now what you need is some kind of Zoom master at every mediation who's going to move these people around, because that's not something that the mediator should be doing in that sense. So that's what I think is one of the cons to this is, although it makes it easy, it takes away the interaction. And we all pride ourselves on sizing people up when you're sitting there, but it's really hard to do that in a virtual setting.
I think, Rudy, that's an excellent point. And it's one of the things that I believe that counsel has to consider in retaining an ADR provider to administer the process. At NAM, the mediators are very highly trained in terms of actually running the virtual meeting itself. And we have complete control over the meeting, and we'll talk about the safety measures that we take. But additionally, you have to have a backup team, which we have, of IT people. And I'm sure many of the mediation companies out there have them, but many of them, and we discussed this, do not. So I think in choosing an ADR provider, whether it's NAM or any other entity, you have to ensure that the mediator knows what he or she is doing in terms of technology, and there's also backup. But this is an interesting dialogue to me, to your point about people meeting in the hallway. What I do on a routine basis, I'll reach a point in the mediation where I believe that hallway conversation is absolutely essential. And I will say to each side, I would like, if you're willing to do this, just to take one person from either side, and I will either put you in a room by yourselves, or I will join you if necessary. And so that's how I compensate for this obvious difficulty of not being in person. And then I'll move them into a room. I did this yesterday, and let them have a direct conversation, particularly when we're getting towards the end and we may be coming to an impasse.
Lauren, did you want to add to that?
Yeah, thanks, Rudy. So I agree with all of that. And certainly there's nothing that beats being in person from sort of sizing people up, as you said. The other thing, of course, is that you can establish rapport more easily when you're together with people. And that includes your opponent, not just your opposing counsel, but sometimes the ability of clients to shake a hand across the table is very important. And it takes maybe the sting out of how people, come into the mediation. They might be angry about the case. I do a lot of defense work. And so I'm oftentimes in a position where a plaintiff comes in very angry about whatever the circumstances are that relate to their claim, and being able to have that rapport and a gentle good morning and a shake of the hand goes a long way for discussions later in the day. So to me, those are important things. The other thing is, I think with virtual mediation, we all have to be careful about the multitask issue, because we can all be guilty of that. We're constantly bombarded with phones, texts, whatever it might be, emails. And when you're participating in something virtually, I actually think it's harder to keep people focused on why you're there. And that includes not just the attorneys, but clients who are very invested in the process, but they are running, a lot of different things at one time. And it's not unusual to be getting emails popping up as you're on a virtual mediation. So part of my job, and I think the mediator's job, is to really make sure that we stay focused on why we're there. and not get weary, because technology, if you're using it 5, 6, 7, 8, 9, 10 hours a day for mediation, can really just make people weary and sort of less engaged.
That's true. There is Zoom burnout. I was in hearings through Zoom in a matter in Anguilla for 2 days, glued to the computer, glued on Zoom, and you just want to turn it off. What do you then make the decision that this mediation has to be in person, or it's okay to do it by Zoom? Because people will often think, well, let's do it for Zoom, it's convenience. But I think the additional analysis has to go. Can this mediation, can this negotiation be successful via Zoom? And I think that's the additional analysis the court needs to make. When you've got people who are angry, for example, the in-person meeting may be just what you need, because in some cases where I've been involved in private practices, sometimes the defendant or the plaintiff wants to hear, I'm sorry, wants a sincere apology, wants to know that his interests are being looked after, and you can't do that in a Zoom.
We talked about that a little bit yesterday, right? We talked about, well, how do you prepare and what are the cons of virtual mediation? And I think I said, sometimes it just doesn't make sense. It just does not make sense for your case, because your objective is to settle the case, to do a mediation virtually. And I think I related a couple of experiences I had during the pandemic. Early on, I had a case where it was out, I practiced in Philadelphia, but I had a case out in the Pittsburgh area, and we knew that case would not settle if those plaintiffs participated virtually. We just knew there needed to be an in-person touch. And so I flew to Pittsburgh when people weren't flying, but that was what was needed for that case. More recently, we had a significant title matter that we knew was not going to resolve unless we could have that rapport being built, not only between the parties, but with the mediator's help, with, sort of assisting the parties. And we elected to do that mediation in person. And I had to convince our mediator in that case, who wasn't doing mediations in person, that we really needed that kind of help. And we got the case settled. So sometimes the answer is virtual isn't the right thing for your case. And I think that's the kind of discussion that, we need to have as outside counsel with our clients.
Picking up on that, and this is the one thing that I would suggest to anyone who's engaging in a mediation from the position of representing a client. And what I see to be as a major problem is that counsel really will fail in many ways to use the mediator to assist in the process. And we're there to serve. I mean, that's really what my role is. I'm there to help you to the best of my ability to get the case settled. And I very often find that the attorneys, we've discussed this, who are most effective, will turn to the mediator, and it could be on any number of issues. For example, the issue of someone who is distracted. Now, the issue of being distracted or multitasking, doing mediations in person, I've walked into breakout rooms and I see an attorney who has an entire case file from a different case spread out on the table, and they're working on it, and they're anything but focused on the mediation at hand. Now, is that always true? No, but it's the same thing virtually. You can have people who are distracted. The mediator is involved, and I don't think a lot of people realize this, in a very delicate dance in terms of what should be said and what they are able to say. And yesterday I had an experience, very contentious, long mediation and medical malpractice case where the allegation was failure to diagnose cancer. And this exact situation came up. One of the attorneys was looking down during the entire joint presentation by plaintiff's counsel, and plaintiff's counsel made a comment and said, well, I know that Mr. So-and-so was working on other matters while I was speaking. And the attorney has said, no, counselor, I wasn't working on other matters. I'm very sensitive to what your client has gone through. And I was writing down the fact that I've had 16 separate surgeries for cancer, and I'm a recovering cancer patient who had metastatic cancer like your client did. So, you have to be careful with that. Sometimes you think the party is working on something else, and sometimes they're making notes. To Lauren's point, what I think the problem is with the virtual process, you can't tell. And that's exactly what happened yesterday. I was looking at this attorney thinking to myself, he's not even listening to us, but I'm not going to jump in and say anything. But, that's one of the problems with the virtual process. You can't really see what the other person is doing. You don't know if they're working on something else. And it's hard for the mediator to weigh in and say anything. The other thing is that I find that, it's so important what Rudy and Lauren have talked about in terms of hearing out the client, letting the client speak to the issues that are upsetting them, disturbing them, what they think their point is. And I always encourage attorneys, I say to them right off the bat, if your client wants to talk to me, I am ready to sit and listen. Just ask me, though. Just ask me. If you want my opinion with respect to an evaluative view of the case, and you want me to share it with your client, ask me to do so. But I find there's very often a failure on the part of the attorneys to say to the mediator, hey, we need your help with this particular thing. I have a problematic client and I need you to talk to them, or they're very angry and I need you to hear them out. So my point is, if there's any way that we can help you, use us, ask us. If we can't, we can't. That's something else. But please use us. Please ask for our help.
We have a question. And by the way, if anyone should have a question, please feel free to go in the chat and we'll address them as we move along. The question is, what about the future of virtual mediation? Do you think this practice will be confirmed in the years to come? And it's absolutely. I don't think we're ever going to go back to this. This is here to stay. And it's not just in mediation. Colleges are doing it. Everyone's doing it. Companies are incorporating teams. It's here to stay. I don't see it going away.
I don't either, Rudy. And so I think, because there are efficiencies that come with this that are really ideal for clients. And, we talked a little bit about what that means then, because knowing this is going to be the common course for many mediations, what do you do to prepare and maybe blunt some of those cons we talked about doing things virtually? And just, to Judge's point, one of the things he said is important to me as counsel, which is I always speak to the mediator in advance of the mediation. I will call and introduce myself and say, want to introduce myself. I represent so-and-so. I know you're going to hear a lot about this case, maybe through submissions, but I just want to let you know who I am before we get on a screen together. And what I see maybe are the challenges or issues surrounding the mediation so that I can have a rapport with the mediator. I find that's hugely helpful because, as Judge said, it then gives the mediator the opportunity to understand the lay of the land, which may not be as easy to pick up on virtually going into the mediation. And I found that is uniformly helpful if you think about it that way. I mean, that's one thing you can do to prepare. And the other thing, of course, is to establish communication protocols. Think about all those issues we've been talking about. How are you going to talk to your how are you going to talk to the mediator if you need to access the mediator? How are you going to speak to opposing counsel? Sometimes it helps to have a separate one-on-one attorney-to-attorney conversation. And how are you going to speak with your own client? Sometimes you're in a room and there are people coming in and out. How are you going to communicate with your client? Will you be texting your client separately? Will you be having a sidebar, perhaps through a conference call? All things to think about, since I think virtual mediation is here to stay.
And that's an important ethical issue too, because when you're texting between each other in Zoom, depending on how it's set up, those texts are recorded.
Well, that's, an interesting thing. And that goes to the security issues that NAM at least has in place. And again, you have to confirm with your ADR provider what security protocols they're offering you. At NAM, very early on, we created a platform while we use Zoom. We are not actually on the Zoom platform. We have our own platform. We have separate identification protocols for people to get in that are encrypted. Zoom cannot collect information from our meetings. Chat is disabled. There is no chat during the course of our meetings. Video recording is disabled. In fact, you cannot even screen share unless the mediator allows it. And that was put into place very early on to prevent Zoom bombing. Not that anybody would get into a mediation and Zoom bomb you. It was probably the least interesting thing that people want to get involved in.
I think there are a lot more interesting things to Zoom bomb than mediation.
And we are also, and this is extremely important, and these are things that you should talk to your ADR provider about. We are HIPAA compliant, and we have been since the beginning. So now, can anyone absolutely assure you that, you know, any platform in this day and age is perfectly secure? No, but I think Rudy made an excellent point. If you're retaining an ADR provider to administer the process, one of the things that you want to ask them is, what security protocols do you have in place? What tech support do you have available? And what knowledge does the mediator have of controlling the meeting? Is the mediator going to control the meeting, or is there going to be a tech person in place? But I just wanted to jump back to what Lauren said, because it's exactly, I think, dead on point what I'm trying to say. So few attorneys pick up the phone and call me before the mediation. I welcome you to do that. I welcome both parties to call me up and establish a protocol. Just tell me, you know, we would like to conduct the mediation in a fashion where we would prefer to go directly into breakout rooms. We don't want a joint session, or we want a joint session and we want to limit it to certain discrete issues during the course of the joint session. Or how do you feel about that as the mediator? Do you prefer to have a joint session? What do you think about in terms of submissions? You know, what do you think about the exchange of submissions? Should there be a submission that is a general submission that will be exchanged, or should there be a separate mediation submission for the mediator's eyes only? And also, you know, you can ask the mediator, what's your style? You know, what is your style in terms of how you conduct a negotiation? I think that Lauren has made such a critical point. And I will tell you that, let's say I have 100 cases, in maybe 5 or 10 out of the 100, do the attorneys take the opportunity to speak to me in advance? And it is such a mistake not to do so, because I think what Lauren is talking about, which is so critical, you're also establishing a rapport with the mediator. You're establishing a line of communication, and you get a feel for what he or she is like, rather than meeting somebody completely cold, you know, particularly virtually. You're really cold. I mean, you're not even seeing this person in the flesh. Rather than meeting the mediator for the first time online, I think, to Lauren's point, there could not be a more important point. Reach out to us in advance of the mediation. We're here to serve you. Again, I can't emphasize that enough.
Well, I think talking to the mediator is a good thing, but I also think there's an additional component that needs to be added. I think there should be a Zoom conversation with everybody to set out the expectations. Too often, people worry about the substantive part of the mediation, but the things that can go wrong will go wrong, and that interferes with the substance of the mediation. For example, I've seen situations where somebody's on their phone trying to be in the Zoom mediation. Be specific about what the client needs to have in terms of technology. Get on your computer, not your phone. I mean, I've seen people, I'm going to hold up my phone, that are on a Zoom call, and they're trying to do this to listen, and what you see is their ear. And then get all the parties comfortable with the security, the technology, how it's going to work. That is important to get these household questions, these housekeeping questions, so you're not struggling with that along the way. Now, Judge, let me ask you this question. When we talk about ethics, now you've got an IT person there who is possibly listening, who's not a party. How are they bound? I mean, are they subject to the attorney-client privilege?
And again, this is, you know, a critically important question, and it goes back to what I discussed earlier. You really should speak to your ADR provider in advance about that. I can't speak for any other ADR provider, but the way it works with NAM is I have complete control over the meeting. I can remove people if necessary and permanently bar them. But NAM's policy is first of all, the techs cannot listen in on the meetings. We're in separate channels, so they cannot listen in the first instance. Secondarily, if they are going to come into the meeting, I always have, and we all do at NAM, a separate line of communication set up. And Lauren, I know, and I talked about having redundant systems, which I put into effect this morning because I didn't like the way my PC was working. But I will always have a separate laptop next to me. And the only way the tech comes into the meeting is if I ask them to enter the meeting. And when they enter the meeting, what will happen is a bell will ring and you'll see what is up in front of you right now, NAM technology. And I will say, everyone, please stop. Or I'll say to them in advance, we're going to have a NAM tech join the meeting. Stop any discussion of the case. However, Rudy, you make a very good point. I can't speak for any other ADR provider. And it's a very good point. We talked about this yesterday. Who's also in the room, potentially, when we have a mediation going on. And I'll toss it back to you and Lauren on that. I don't want to go too far with this.
Lauren, you want to comment on that?
Sure. So I want to just go back to a really important point the judge raised earlier, which is think about who you're choosing to serve as your mediator. I mean, right. Judge just laid out a whole host of sort of administrative support and strategy that can get you comfortable that you're using the right service for the mediation that you're doing. Early on in the pandemic, I had a mediation with a local mediator who was a one-man band, and he was launching into the virtual world at the same time everybody else was. And he struggled to use the technology that he needed for the mediation. That was really disconcerting for us as users of his service. And it was not productive for trying to settle the case because we were so concerned. And it wasn't just, the defendants, it was every party in the case about whether we were actually, the rooms were being switched and things were happening the right way, that it actually became a distraction. So to me, one of the first decisions you need to make, even now, when we're used to virtual mediations, is who are you going to use to support the mediation, and are they capable of handling not only the tech issues, but are sensitive to some of the privacy privilege issues that we've just talked about?
Well, we've all had to be IT people in some form because we're all doing this using Zoom or Teams in some form or another. I also think there needs to be an admonition in some cases, probably in all the cases. For example, if I wanted to, I can take my cell phone, it's on speaker, and I can record the entire proceeding outside of Zoom. And that's honestly, I think, some people's fears. Well, we're in the Zoom call, but I don't know what recording devices are outside there. And if you're in a, this is not on topic, but if you're in a deposition, who's there behind the wall feeding answers? And those are issues that come up.
Yeah, that is, and I'll address that. And my generalized answer is that if the mediator does not address these issues up front, then counsel should request. Again, I go back to the same thing, that the mediator address these issues. And, I'll give you a checklist as to what you should be asking. But I just wanted to touch base on a point that Lauren made that I think cannot be emphasized enough, and that is the importance of personal contact. And Rudy, you mentioned this also with the mediator and maybe all the parties, on Zoom beforehand. And it's just a very short war story I will tell because it's one of the few cases that I'm free to discuss because it was a public matter where the settlement had to be approved by the County of Westchester. And it's the Jeffrey Deskovic case where he was vindicated of committing a rape and murder for which he was incarcerated at the age of 16 for a period of 16 years. And not only completely vindicated, the person who committed the crime was found in California serving a life sentence for a similar crime. But this is a young man who went into a correctional facility, maximum security facility at the age of 16 and got out in his 30s. And when I was asked to do the mediation, I immediately said to the parties, it wasn't suggested to me, but I said to the parties, I said, I really feel I need to speak to Jeff Deskovic before this mediation. I took it upon myself. And they said, why? And I said, I'm going to be discussing, this horrific miscarriage of justice and mediating a case that's so incredibly, impacted and to a great extent destroyed the life of a young man. And it makes absolutely no sense to me to meet this person on the date of the mediation itself. I'd like to meet him in advance and be able to establish a rapport. And I met with Barry Scheck's firm, Nick Bruston and Jeff Deskovic, and I talked with him for 3 hours. When I say I talked with him, I listened to him for 3 hours so I could get a full appreciation of what he had gone through. So I just wanted to touch base with that, because that was really instrumental in getting the case settled, because we had a rapport. I had the ability to speak with him, and there was a foundation of trust that was established. In terms of the admonitions, and I think Rudy makes an excellent point, and I've actually lectured on this, written about this. My first point is, if the mediator doesn't do it up front, you should request the mediator to give these instructions. And I think, Rudy, you brought up an incredibly important point. We at NAM can do everything possible to secure the platform, but I cannot, or we cannot, control the behavior of individuals who are on the screen. And you're absolutely right. Someone could be recording the process. Someone could be recording the negotiations. Someone could be recording the arbitration process. So the first admonition that I normally give is no one is allowed to record this process. Recording is disabled. It would be unethical to do so. You're not allowed to do so. The only exception might be is if the parties agree in an arbitration to have the proceedings transcribed, but I give that instruction up front. The second thing I say to the parties is, I can only see the person who's on the screen, generally speaking, although sometimes I will be able to see two lawyers. I ask that, are you, or the person who is on the screen, are you the only person in the room? Is there anyone else in the room with you who is listening to this mediation process? Who is that person, and what is their role during the course of the mediation process? I'm going to ask you not to use any other electronic devices during the mediation process and give your full attention, I think, which Rudy and Lauren have pointed to. And can I guarantee this? Of course not. But I think it carries weight with attorneys when the mediator says, I need your full attention during the course of this process. Respectfully, you shouldn't be multitasking when we're in a joint session. I certainly can't control what you do when we're out of it. But also, please turn your phones off, because I've had that happen in the middle of a mediation. And I will admit, I'm guilty of it. It's happened to me where I didn't put my phone on Do Not Disturb. It happens. But the reason I say it at the beginning of the mediation is also as a reminder to myself to silence my phone and put it on Do Not Disturb. And then, I always remind the parties that everything that we discuss is completely confidential, and then proceed with the mediation. And obviously, if there are any other instructions that would be particularly applicable to the case, I always take the suggestions of the parties. But my point is, if a mediator who really is experienced in this field and is working full-time as I am should know and should do this. But so often I hear from attorneys they don't, because when I give these instructions, they're sort of looking at me as if I have three heads, that it's obvious. It's not obvious. And I mentioned this yesterday during the course of the preparation for this, where I was in the middle of a joint session, and all of a sudden, this is very early on, where I hear someone in the background say, "Now we got him." And I said, "Excuse me, who just said, 'Now we got him'?" And one of the attorneys said, "Oh, my expert is sitting in the room listening to the joint session and the presentation of counsel." And I said, that should have been disclosed immediately. Well, shame on me, okay? And this was very early on. Shame on me for not giving that instruction. So those are the admonitions, but use your mediator. Again, I keep on emphasizing that.
I find from a trust point of view that, and when I deal with people in Latin America, they really don't trust Zoom. They don't trust Teams. They don't trust anything. I find that I get more frank conversations when I'm face-to-face with them, for the simple reason of they don't know if you're recording. And so you have to have really a lot of trust factor when it comes to that. And I think that's why I think the initial call is important. So if at the very least on the phone, set up the trust factor. I can remember trying some cases in St. Louis, and one judge would say to me, "Yeah, sometimes I introduce the lawyers for the first time when they're in a pretrial conference. Oh, by the way, this is your opposing counsel. Oh, nice to meet you." Yeah. The virtual age has basically eliminated a lot of that. I think that's something we need to go back to.
Yeah, it really is all about preparation. I mean, we keep coming back to different issues and how to address them, and it really is all about preparation. and where do you start with that preparation? And it begins as early as deciding whether you're going to have virtual mediation or not. And if you're going to have virtual mediation, who do you choose for the mediation? And then if you're going to do virtual mediation, how do you prepare your client for that process? I mean, I just think there are so many things we could talk about in terms of establishing parameters for how you do this. It's not as simple as opening up your laptop and just deciding to do something a little differently. I think there's a lot of strategy that needs to go into how you do it. And your objective is to settle your case, right?
Well, there are two practical questions I've had for each of you. When you come to a settlement and everyone's there in person, you sign a memo. It says, this is the agreement. So nobody has buyer's remorse and you can enforce a settlement. Judge and Lauren, I would ask, how do you do that in a virtual mediation when nobody's there to sign? How do you pass around this memo? Would you use digital signatures when you draft the memo? I've seen as much as like 5-page memorandum of understandings in mediation say, yeah, this is the agreement.
Mm-hmm. Well, I think that, and again, I just want to jump back to something, Rudy, that you and Lauren discussed, which is what I would suggest to, again, anyone who's doing mediation, and particularly when you said settlement, that triggered this comment. Do a conflict check. NAM does conflict checks on every case that we have. If you're doing a mediation with me, you can request a conflict check. And it's not so much, you can request a conflict check, yes, but you can also see how many cases out of the 4,000 cases I've mediated over 15 years, have I mediated X number of cases with a particular law firm? Have I ever mediated a case with the same attorney from a law firm? What were the results with respect to those cases? So one of the other things that I would suggest doing, NAM does this as a matter of course, is to do a conflict check. In terms of the preparation of the agreement, why that's particularly interesting to me this morning, and people probably have not seen it yet, but there's an article about the ADR provider in California, not NAM, obviously, with an attorney who is a special referee using former judges. The allegation is, and I don't think it's contested, that the attorney was diverting incredible sums of money for his own purposes, and that there was a collusion on the part of the former judges who were acting as either mediators or participants in the process. So when you say signing off on a settlement, and they were signing off on the settlement, I found it appalling to read that this morning, but it came immediately to my mind because you have these judges signing off on settlements, and that goes back to the conflict check. And in the course of the article, you'll read it. Many of these judges were associating or socializing with this attorney outside of the ADR process, which is something that a mediator should never do. The only time I would ever see anyone who would be mediating a case in front of me would be at a bar function, but I would never socialize with anyone. In terms of the settlement, what I do typically is I will ask the parties to give me all of the terms of the settlement. This, of course, is case dependent. I will prepare a draft settlement agreement. Now, it's not an agreement. Obviously, it's subject to a formal agreement being entered into the parties. If I'm asked to do this, in other words, I have all the terms, and I'll say what I will do is I will circulate this draft of all the principal terms to the parties, and I want everyone to confirm by email that they are in agreement with all these terms, or if there are additional terms being requested, that they provide me with those terms. So to answer your question, Rudy, what I try to do is to memorialize, obviously, if it's a monetary settlement, what the amount of the settlement is. If there are major specific terms, I want those terms memorialized, circulated between the parties. And in point of fact, what I do very often is I keep everyone online until I have what is in essence an agreement that's been confirmed electronically by everyone as to the terms. Now, of course, you could have non-disclosure agreements, non-disparagement agreements. The parties agree to non-disclosure, non-disparagement, they agree to that, but then they're going to fight it out as to what that exactly means thereafter. But I think it's critically important for the mediator to stay online, to get the principal terms of the agreement memorialized, whether you're asking me to do it, to circulate a memo, or the parties are going to do it. but I don't let anybody off until I have a formal agreement with emails confirming everything. So I have it as the mediator, because in New York, as in many states, if you sign off like that, it's entirely enforceable in court. Now, you may be subject to the nuances of what is a non-disparagement agreement, but the principal terms, particularly the monetary amount of the settlement, will be enforceable.
Lauren, how would you handle that? You're not there to sign a memo. Is an email going to be sufficient?
No, I don't think so. First thing I would do is have a conversation with my mediator in advance as to the expectation around signing an agreement. And I would want to understand that before the mediation so that I can discuss those expectations with my client. Because my client's likely going to be sitting in a different place, not maybe in a different state. And they're going to have to be, as counsel, I want to make sure that they are as on board with what we're agreeing to at the end of the mediation as I believe we are. So first and foremost, I'd speak to the mediator and say, what form do you typically use, or should this take? Then I'd also want to make sure my opposing counsel understands that. I mean, I work to have, good relationships with opposing counsel. I'd want to make sure we have a conversation about the expectations so that everybody's clear, either through the mediator or directly, as to what the expectations are. And then I'd want to understand the protocols for actually having that happen. So we know when you sit in a room, and we've been there a lot, Rudy, you and I have sat in a room together and done this, where we're at the end of the mediation, we have a settlement, we think in principle, the mediator comes in with a one-pager that says you agree to X, Y, and Z with additional terms to be, fleshed out when a full settlement agreement is prepared. And we all say that looks about right. And we sign off, and we then proceed to formally settle the case through a settlement agreement. That all works well, but in a virtual setting, that's not easy to do. So the question is, what, to Judge's point, what do you do? How do I want my client's signature on that? Is that helpful to me as outside counsel to make sure my client's signing, and not just counsel? Do I want that of my opponent? Those are all things that I think I would want as outside counsel. And the only way I see of achieving that is to talk about it in advance and understand how electronic signatures can be used or shared during the course of the mediation. It may be as simple as my client signing it and scanning it back. But those are the things that you get to that point at the end of a long day and you say, oh, hadn't thought about that. I better think about, it's kind of late to be at 6, 7, 8 o'clock at night thinking about that. But I think those are, again, preparation is key. That's part of the prep.
Well, the digital signature is also something you can do. I mean, most the Adobe programs can, and any other similar programs, you can digitally sign and send back. Yep. You don't need the wet signature anymore.
And to Lauren's point, and this is a caveat, I mean, the majority of cases, the attorneys will say, well, this is subject to a further formal settlement agreement. I really can't control that. But the caveat is I've had 4 cases in the last 15 years, and there's a body of case law on it because I had to write a decision on one of these arising, oddly enough, out of an arbitration that was converted into a settlement, where email communications are sufficient in the majority of courts in the United States to enforce a settlement agreement. So the caveat is be careful what you're agreeing to by email, because the courts will enforce it.
As a practical thing, one of the things that we look to in a mediation is the food that the mediator provides, because you want to, as a mediator, you want to keep them there. You don't want them going out. You want to keep them there. Sometimes you walk into the room when they're eating a sandwich and you're still talking about the case. How do you handle that? I mean, when people want to take a lunch break, they're probably in different places, but do you set up a specific time? I need you to be back here, because that's one of the downsides, I think, to doing the virtual mediation is keeping them there, keeping them fed so that they don't go someplace else and they don't have time to really think way too much about the mediation.
Yeah, that's such a great point. And I always tease the attorneys and saying, well, NAM's going to provide you with a virtual lunch around 12 o'clock. I normally will schedule, I'll say to the parties up front, look, we're going to be going for 8 or 9 hours here. let's figure out when you would like to break for lunch. So we all break simultaneously. It's important for the mediator also, because I need a break. I find I'm working harder in virtual mediations because there's not that lag time in terms of moving back and forth between rooms. So I always set up a time, during the course of an 8-hour or 9-hour case that's going to be going, to say to them up front, look, we're going to break, approximately from 1 to 1:30 or 1 to 1:45, whatever you feel you need. If you need an hour, that's fine. We'll do an hour, and if we have to add that on at the end of the mediation, that's fine. But it's a good point. Keep their sugar levels high, and the case will probably settle.
And one other question, and we've talked about this yesterday, Your Honor, and in my experience has been, especially in California, when I have a former judge as a mediator, they often think they're still on the bench. And right. You better settle because, well, when they're on the bench, they say, well, you better settle because you don't know how I'm going to rule and you may not like my ruling. And those of you in the audience who've tried cases, I'm sure have heard that. But you had a really, really interesting way of addressing that, which I thought was really clever. Why don't you tell everybody your comment on that?
And I learned this very early on. I've always said that the best mediator who is a former judge is the mediator who has forgotten the fact that they ever served as a judge. Because while some of the skills are, applicable to the mediation process, you do not have the let's say powers available that you do when you're sitting as a judge to push a settlement forward. For example, advancing a discovery schedule, advancing a dispositive motion schedule, advancing a trial date. And we all know, as former trial lawyers and judges have the ability to do that, to push a settlement, or the judge starts giving you a dirty look or rolling his or her eyes when you're talking about what your settlement position is. There's a fear factor associated with that. And I found that when I became a mediator, having none of those powers, I had to use my wits to get people to do what I believed would help them reach an amicable settlement. And I had a friend who made a comment to me once and said, "You have no power. You mean they actually pay you for this?" I go, "Yeah, they do. They do pay me for this." But, I don't, you can't strong arm people, and again, I think this goes back to what Lauren was saying, is that, what is your mediator's style? I like to sit and wait until the appropriate moment when the parties are ready to hear what I have to say. And then I try to do it in the most fair, impartial, and reasoned fashion that I can, but in very clear terms, telling them what my evaluation is of the case.
Lauren, you want to comment on that? I know you and I have been at the same table, and we've had judges and non-judges as mediators.
Sure. Judge, I'd love to have you as a mediator. You just hit the nail on the head. It is hard when you realize that you think you're in one process and you have somebody who's sort of working with you as a mediator, and you discover that this former judge is still acting like a judge and mediating the case. It makes it a lot harder for people like me. Because it's really, that's, as you mentioned, Judge, that's just not the process, right? It's a little bit more collaborative. I'm relying upon the mediator to be collaborative with me, with opposing counsel. That's all part of the process. And if you feel like you're getting strong-armed, and I've had that experience. I've had that experience with several mediators who are former judges. You just, first of all, you're not happy, your client's not happy. A happy client is important, somebody who's satisfied with the process. And if your client feels like they're just getting pummeled because the mediator is acting effectively like a judge would and saying, you got a loser of a case and you better come up with X, and do you know what this case will look like when it goes to trial? Those are all things that are really hard to deal with as outside counsel, in terms of tempering the situation and keeping.
But Lauren, they'll go to you and say, "How come you picked this guy?"
Exactly. That's right. That all comes back to me. Why did we ever agree to mediate before this particular mediator?
No, and again, it goes to the mediator's style. And I know there are a lot of mediators who are hardcore. They're former judges or not former judges. But the way I view a negotiation is this: you have to hear the party out. And before I give my opinion or my evaluation to the client or to the attorneys, I always ratify the arguments that they're making that are valid. And I give recognition to what arguments they are making that are valid. You know, it's not just like, well, I think you should do this on the case and you're going to lose the case and this is what's going to happen. But then what you have to do is say, you know, but respectfully, and I always say, you know, my opinion in $2.50 will get you the New York Times, but you're paying me to give you my insight, having done this for many years. I think these are factors that you should look at that are going to affect your case as it goes forward. Now, that might be in terms of the venue that it's in or legal decisions that the court may make. But I think the critical aspect for a mediator is, and the way I've always looked at it, and I was the same way as the judge, I always looked at the attorneys before me as my colleagues, even though I was the judge. And I viewed the attorneys who appear before me at a mediation with the utmost respect. And I'll often say to them, you probably don't need me to tell you this. But I think the critical thing, and it goes back to Lauren, what Lauren was saying, if you strong arm a client in front of their counsel, the client's going to be saying, why did I pick this guy? And particularly if the case does not settle, and the mediator has heard them out and has ratified portions of their position, the client walks away with the feeling that they were treated fairly and that they were heard, even though a resolution could not be reached.
Well, you know how you tell a former judge in a mediation to jump off a bridge, right? With all due respect, Your Honor, you're not. It's true. You're not on the bench.
Exactly.
We're close to the end. I'd like to just end with some takeaways from today's webinar. And the first thing is, I think you need to be more prepared. Is number one. Understand the technology more. And number two, understand that you're not going to have the same personal dynamics that you're going to have as you would in a live session. So as a lawyer, inside counsel, outside counsel, you need to adjust your strategy on how to settle the case. Be more in tune with the technology and make sure that the provider of the services is equipped with the technology, because nothing happens worse than when you see somebody's going to speak and they're going to say something brilliant, but you can't hear them because everything is garbled. Concentrate more fully in a virtual Zoom because you really have to devote your attention to it. Don't multitask while the mediator's there and you're checking your emails and you really half hear what they say. Turn off your phones. Don't record on your iPhone when somebody is in a mediation for posterity's sake, right? Don't take a screenshot. Any other takeaways you can give? We're at 10 o'clock, but I think we've got an extra 30 seconds. Lauren?
I think you hit them, Rudy. I mean, from my perspective, these are the takeaways. And I think the sort of the last thing about I would add is we talked about preparation even before the mediation. We talked about virtual mediation, but sort of make sure you got your case down and you understand why you're there and be efficient about the process. And virtual can help you in that.
And my last takeaway would be to say, use your mediator. You know, we're there to help you get the case settled. And there's no such thing as a foolish question. If you want our opinion, doesn't mean you have to accept it. But at every stage of the process, right from the beginning through the end, seek our assistance because we're all very happy to help in any way that we can.
Well, thank you, everybody, for showing up today. We've had really great attendance. And thank you, NAM, for providing the technology and the platform for this. You can see if it works during this webinar, it'll work during a mediation, right? Thank you, Lauren, for Fox, for participating. I know both you, Judge, and Lauren, your time is valuable. We appreciate it. And thank you, everyone, for taking an hour out of their day to attend the webinar. We hope you learned something. And thank you again.
And I'd just like to thank my fellow panel members. This has been an absolute pleasure working with you. And I think one of the most interesting webinars I've done in a long time.
Yes, thank you, Judge. Thank you, Rudy. It's been great. I think the perspectives that we each bring to this really round out the discussion. And been a pleasure to work with you.
Thank you. Goodbye, everybody.
Take care.